prosecute domestic violence and under the diversion program through the prosecutor's office or the statute. And no upfront jail is part of the agreement, and a Cobb's agreement at this point, Your Honor, with your consent.
All right, is a killabrew between you and the prosecutor, or to no upfront jail?
Yes.
Okay. All right. And Miss Adams, do we still not have prints on Mr. Hernandez? I show no TCN.
Yeah, he does. He's indicating to me he doesn't think he got them done yet.
Okay, well, we gave him an order back in May to get those done. So he needs to contact the Madison Township Police Department.
You're right. I forgot to do that. Yeah.
Yes, he will.
Yeah, I'll do that today. I'll go there today after this.
Well, you gotta set it up. I don't know if they do them. I don't even know if they do them on site, but you may have to make an appointment, okay?
Okay, I totally forgot. I don't know why. I'm sorry about that.
Well, don't do that. All right, Mr. Sneed, so will we be adding a count 2 domestic violence first offense?
Yes, Your Honor, there should be an amended information that was provided to the court as well as partial police.
Yep, I do have it. Okay, good. Thank you, Mr. Sala.
And a
All right,
partial,
so go ahead, Mr. Sala.
and a partial police report, which for the factual basis of the plea.
Mr. Sneed or Mr. Sala, who will be placing the factual basis on the record?
I will.
Okay, is that all right with you, Mr. Sneed?
Yes, thank you.
All right, so Mr. Hernandez, I'm gonna need you to scoot up so we have good audio and I can see your face. Very good. All right, can you raise your right hand for me? The other right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, can you state your full name for me?
Pedro Hernandez Jr.
All right. Now you've heard the statement of your attorney and the prosecuting attorney, as well as there is a plea agreement form. Is it your intention to plead guilty to an added count 2 domestic violence, which carries a maximum penalty of up to 93 days in jail and or a $500 fine, with the agreement that it would be under the MCL 769.4A deferral program with no upfront jail? So is that your understanding of the plea, and is it your intent to plead guilty to that?
It would be no contest, Your Honor, but
Oh, no contest. Is it your intention to plead no contest?
Yes, Your Honor.
Okay, and you can put your hand down.
All
All
right.
right. Are you satisfied with Mr. Sala as your attorney and the advice that he has given you?
Absolutely.
All right. Now, there has been a plea agreement placed on the record, and the court will honor that. And you understand, Mr. Hernandez, if I didn't, you would have the right to withdraw your plea. Do you understand that?
Yes.
Okay.
you have to speak up.
Other than the plea agreement that was placed on the record, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Sala?
It is, Your Honor.
And Mr. Steen?
Yes, Judge.
And Mr. Hernandez, is that correct as far as you're aware?
Yeah, my awareness, yes.
Okay, good. If a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you might have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Sir, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable had you been convicted at trial? Do you understand that, sir?
You understand you're giving up all your
Yeah,
appeal.
yeah, I understand.
Okay. Okay, do you understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right? Do you understand that?
Means you have to ask for an appeal. You have no right to.
Yeah, I understand that.
Okay, do you understand that if you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization? Do you understand that?
I do, Your Honor.
Do you have any questions about the rights that I've given to you?
No, ma'am. No, Your Honor.
All right, and the plea agreement is that you would be pleading no contest. So your answer to my next question would either be no contest or not guilty. Do you understand that?
Yes, Your Honor.
Okay. So how do you wish to plead to the charge that on or about February 17th of 2023 in Madison Township in the county of Lenawee, that you did commit the offense of domestic violence?
No contest, Your Honor.
Okay, very good. Has anyone made any threats or promises to you to induce you to plead guilty or no contest to this charge other than what was placed on the record?
No, Your Honor.
All right. Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as the result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? Mr. Sala?
No, Your Honor.
And Mr. Sneed, I believe Ms. Arnold's here, so I don't know whose case this is, but is that correct as well, Mr. Sneed?
It is correct, Your Honor.
Okay, so Mr. Hernandez, other than the no upfront jail, has your attorney promised you any particular sentence or estimated what your sentence will be in terms of fines, costs, probation terms?
Absolutely not, Your Honor.
All right, is it your own choice to plead no contest?
Absolutely.
All right, so Mr. Sala, if you'd like to place the factual basis on the record.
Thank you, Your Honor. May it please the court. I have a copy of the police report drafted on or about February 17th of 2023, which he was dispatched to a residence where a Danielle resided. She's also named in the complaint, Danielle Vila. And according to the police report, Miss Vila indicated to the officer that Pedro pushed her down. He wanted into the house, and Danielle stated that Pedro pushed her down under the ground, Your Honor. So.
Ms. Arnold?
Your Honor, we'd also need to establish the venue for the offense and that they had a child in common, which is the variable that's charged for count 2.
Okay, that's correct, Your Honor. We would indicate that this occurred on or about February 17th of 2023. And it would have been in Madison Township, Lenawee County, Michigan.
And that they have a child or children in common.
They have 2 children in common, and then the basis for the no contest plea is there's a custody issue involving one of the children.
We do separate.
So civil liability. Okay. Anything else to be added, Ms. Arnold?
No, thank you, Your Honor.
All right, based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on or about February 17th of 2023 in Madison Township in the county of Lenawee, that the defendant did make an assault on a Danielle Vela by pushing her down to the ground, and she did not consent to that touch, and that the parties do have at least one child in common. And therefore, the defendant did commit the offense of domestic violence, and the court accepts the no contest plea. Has the court complied with MCR 6.302 B, C, and D? Mr. Sala?
It has, Your Honor.
And Ms. Arnold?
Yes, Your Honor, thank you.
Court also finds that the plea was given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. There has been a Killebrew agreement placed on the record, and the court will honor that. I'm going to refer this matter to the District Court Probation Department for a pre-sentence investigation. Mr. Sala, are you available for a sentencing at 8:15 in the morning?
No, Your Honor, I am not.
Ms. Adams, I'm looking for another sentencing date.
Judge, we could actually do November 9th at 8:15. I just took that date off because the PD's office is not available.
All right, November 9th at 8:15.
I'm actually at a seminar learning more of the law.
Ms. Adams,
All right, and then we can. We could
you
do
don't have to,
November 30th.
November 30th at 8:15.
I'm not available that day.
November 29th.
Actually, that week, the week of the 27th through the 4th, out in Iowa.
All right, Ms. Adams, what about November 15th at 11:30?
That will not work.
What week are you here, Mr. Sala? Not
December,
learning about
December 7th, December 6th, December 5th.
Okay, so Ms. Adams, December 5, 6, 7. Do we have anything available at all that day?
We could do December 7th at 8:15.
That one work.
All right, so we will set this for sentencing on December 7th at 8:15. Mr. Hernandez, not tomorrow, but next Thursday. And you can't forget this, okay? A week from tomorrow, you need to report to the District Court Probation Department and check in.
Okay.
Because it's a misdemeanor,
Listen,
you will meet with them. Because you pled no contest, you don't have to make any admissions about the offense, but you do need to be truthful with them about your background. They'll prepare a pre-sentence report. We will provide that to Mr. Sala. Mr. Sala will review that with you. And then we will be back here on December 7th at 8:15. So 1, schedule your fingerprints. 2, report a week from tomorrow to District Court Probation on the first floor. And 3, get in contact with Mr. Sala to review the pre-sentence report for sentencing on December 7 at 8:15. Mr. Sala, anything else, Ms. Arnold or Mr. Sala?
No, thank you, Your Honor.
no, Your Honor, thank you for helping with my schedule. Appreciate that.
Well, we always like people to learn about the law, so thank you.
Judge, will that be via Zoom?
Oh, Mr. Sala, does your client wish to appear in person or Zoom?
Zoom would be fine.
So we will do that via Zoom. All right, thank you.
Thank you. Thank you, Ms. Arnold, for your help.
Thanks.
So I believe the next attorney I had was Mr. Goldstein. Ms. Adams, Mr. Goldstein has a client in custody, Kenneth Armstrong, but I might have him, because I have the jail. And I have Ms. Tyndall here, but I don't think there's a hearing today. So let me see what she's doing here.
Judge, can I do a breakout with Mr. Goldstein while we wait on Mr. Armstrong?
Sure. Yeah.
Judge, I never have a problem talking to Mr. Malaro, but I do have another client. If we could do that one real quick, and then I can talk to Mr.
Yep.
Malaro.
Okay.
Hold on a second. Miss Tyndall.
Yeah.
Are you here for your Braxton, Tyndall?
No, I'm here for Caleb.
Caleb Simpson?
Caleb Hutchison.
Okay, hold on. Oh, there we go. Okay. All right, thank you. I was checking to see what it is. I'm gonna go ahead and mute you, okay, ma'am?
Yep.
All right. All right, Mr. Goldstein, you have Mr. Armstrong. And Who are you coming in on today then, Mr. Goldstein?
James Smith. It was supposed to be added to your docket.
It was, hold on, let me find him. There you are, it's Mr. Smith, I think he's in my waiting room, so let me let him in, I have James. Mr. Myers, I see you too.
Morning, Judge.
Good morning.
By the way, Mr. Veneps, I believe, is in the waiting room.
Who?
My client, he's,
Okay, I'm gonna take Mr. Goldstein first, so I'll be with you in just a minute.
Yep,
All right.
thank you, Judge.
All right, Mr. Smith is connecting to audio. All right, Mr. Smith, can you hear me?
Yes, I can now. I was trying to get the phone together.
Yeah, there you are.
I know you got a cigarette in your hand, but just don't smoke it on screen, all right?
Yes, ma'am.
Because we're still in a courtroom. All right. This is in the matter of the people of the state of Michigan versus James Earl Smith. We have two files, 22-20810FH and 22-20811FH. I have David Goldstein appearing on behalf of Mr. Smith, and I have Isaac Sneed appearing on behalf of the people. Mr. Goldstein, how would you like to proceed today?
Your Honor, we asked the court to put this on today because we thought we had a resolution. It turns out we don't. But Mr. Smith did want to appear this morning because he wishes to waive his right to a trial by jury and have this matter to proceed with a bench trial. It requires Mr. Sneed's consent. He was unaware of this because I just learned this from my client this morning.
Okay, we are set for trial on file number 22-20810FH on November 7 of 2023. We have multiple charges. Mr. Sneed, what is your position on his request for a bench trial?
Yeah, I'd like to set it for a bench trial, but I would like to pick a different day. Your Honor, if you recall, we set the Alan Crystal jury trial for November 7th. And I would like to proceed on that case to a jury trial with Mr. Smith. I think the bench
Hold
trial,
on. I don't, Ms. Adams, has Crystal set that day as well?
Yes, Your Honor, it is.
And Mr. Goldstein, and or from the jail, I'm sorry to keep you waiting. If I could get Mr. Armstrong next, please.
Okay, Your Honor.
Thank you. Mr. Goldstein, what were you going to say about Mr. Crystal?
No, Mr. Sneed is correct. We set this as a backup to the Smith trial, Your Honor. But we're doing this if we're doing this as a bench trial, we don't, we should probably use that date. Although I would hope that Mr. Sneed and I can get Crystal worked out, but we may or may not.
So Ms. Adams, if you want to bring the books in to me, you can, but I don't think we have anything until after the first of the year, Mr. Goldstein. Would that be all right?
He's not in custody, Your Honor. That's fine.
Okay, and I have that this should take about 2 days. Would it be less with the?
That was a bench trial. With a bench trial, we should be able to do it in a day, I would think. I don't think there's about 3 or 4 witnesses.
Okay, all right.
Is that correct, Mr. Sneed?
yeah, I think half a day would be fine.
Okay.
In light of the evidence.
So let me get to.
Mr. Sneed, did you see my chat to you on Armstrong?
I did.
Okay.
So, Mr. Goldstein, I could do Tuesday, February 6th.
Okay, I've got to find it, Your Honor, just a minute. Your Honor, I have a jury trial starting Monday in Washtenaw County. It's a retrial of a case that hung, and I know they're going to want to get it tried, so probably not going to work.
Okay, Tuesday, February 20th.
Your Honor, I leave for vacation on the 10th of February, and I'll be gone until the end of March.
All right. the 10th of March.
Yes, Your Honor, till the end of March.
Okay. Tuesday, April 2nd.
Okay, let me check. Yeah, that'll work.
That's not spring
Mr.
break.
Steve?
is it? That's not spring break, is it?
No, last week of March is spring break.
Okay, yeah, that works then. Thank you.
Okay, Mr. Smith, obviously you have a right to a speedy trial, but with the, we're still kind of dealing with the cases from the pandemic and winnowing through them. So do you have any objection to me setting this bench trial for April 2nd?
No.
Okay,
No.
thank you, Mr. Good, all right. So April 2nd of 2024 at 9 a.m.
Oh, no.
And then, Mr. Goldstein, how about I set a final pre-trial for, let's see. How about January 10th at 8:30?
That's fine.
Anywhere.
I'm sorry, what, Mr. Smith?
I was writing down everything you said.
Okay, all right, well, I'm filling out a scheduling order. We will make sure to get that to Mr. Goldstein. So we have a final pretrial on January 10th of 2024 at 8:30 in the morning and a bench trial date of April 2nd of 2024 at 9 a.m. And Mr. Goldstein, we will get the scheduling order out.
Your Honor, the other case should probably be set for a pretrial.
Yes.
At the same time.
Yeah, I'll set the other case for pretrial. All right, thank you, Mr. Smith, and thank you, Mr. Goldstein, on that one. So you're all set.
Thank you.
All right, so I'm going to open a breakout room with Mr. Goldstein and Mr. Malaro. So, did you want a breakout room on Mr. Armstrong? Is that why you were?
Yes.
Okay, so Mr. Armstrong, I'm putting your attorneys together in a breakout room. And then when they get back, we'll call your case, okay?
Yes, ma'am.
All right, you should have gotten an invitation to join. Okay. Mr. Myers, you have, who do you have?
Kyler Vineps, and he should be in the Zoom waiting room. Theoretically.
Let me find him. So who in here is a defendant with a court date today? Anybody? You are? What's your full name?
Russell.
Okay, hold on 1 second. Right, so I have a gentleman in a black shirt with a beard. What is your name?
Timothy Nowak.
Spell your last name.
Nowak.
All right, and who's your attorney?
Mike.
Generated.
I forget his last name. Mike. Kate.
Dagmar goes in. Okay. All right. And then I have another gentleman sitting in front of a light curtain. And I don't know what you have on your shirt. Looks like flowers, but It may not be, but what is your name?
Kyler Van Epps.
Okay, and that's your client, Mr. Meyer, correct?
Yes, Judge, that's right.
All right, this is in the matter of the people of the state of Michigan versus Kyler Sean Van Epps, file number 2023-21546FH. I have Sean Myers appearing on behalf of Mr. Van Epps, and he's P78687. And I have Isaac Sneed appearing on behalf of the people. This is the date and time set for arraignment in this matter. Mr. Myers, do you waive the reading of the felony information?
Judge, we've received it and it's, we're all set with that.
Okay, and you received a copy of the prosecutor's request for discovery witness list as well?
Yes, Judge, I have.
All right, will your client be entering a plea today or standing mute?
Judge, my client will be standing mute.
Okay, so I will enter a plea of not guilty on behalf of your client. And how far out would you like a pretrial?
Approximately 3 weeks, Judge. We think we have this resolved, but we just need to wait till Mr. Bayonet gets back from honeymoon.
Okay. Would November 1 at 8:30 work for you?
Just one moment's brief indulgence. Unfortunately, Judge, I'm in trial that day.
I have November 8 at 8:30.
Thank you, Judge.
So because it was an arraignment today, my staff will prepare the notice of hearing. So Mr. Van Epps, you'll receive that in the mail as well. And we'll see you back here for a pretrial on November 8th at 8:30 in the morning, and I'll continue your bond. Thank you, Mr. Van Epps. Thank you, Mr. Myers.
Thank you, Your Honor.
Thank you, Judge. Have a great day.
You as well. All right. Mr. Goldstein and Mr. Malaro, did Mr. Malaro come back? Yes, he did. So this is in the matter of the people of the state of Michigan versus Kenneth James Armstrong. We have multiple files, 23-21474FH, 23-21475FH, 23-21476FH, 23-21477FH, 23-21478FH, and then also a PPO violation on file number 23-50607PP. So, Mr. Goldstein and Mr. Malaro, how do you wish to proceed today?
David I. Goldstein, I appear on behalf of Mr. Armstrong on the criminal matters, Your Honor. Mr. Malaro is here on the PPO violation. Your Honor, there are a lot of moving parts, as you can imagine, in this matter. Made a little more complicated by the fact that there are 2 prosecutors and 2 defense attorneys. But we have been talking. We are very glacially moving toward, hopefully, resolution. I was going to ask for 2 more weeks so that Mr. Sneed and Mr. McCready and Mr. Malaro and I can communicate. Mr. Malaro informs me that his case is coming up for arraignment next Wednesday. And I think he and I both would like to see that kicked also to the following week. So all the cases are in front of you at the same time.
All right. So, Mr. Malaro, on that arraignment, are you going to file a waiver?
Your Honor, I would have to speak to Mr. Armstrong about that.
Whatever you think is best, Mara.
Whatever you think is best, Mr. Malaro.
Well, I would certainly advise him to give me permission to sign the arraignment waiver on the charges that were found over from last week.
So, Mr. Armstrong, you can either come into court and waive it, and I can set it over to that date, or you can allow Mr. Malaro to sign your name with permission and do the waiver form, so I could set them all on just one date. So,
That's fine.
Okay. So, Mr. Goldstein and Mr. Malaro, because there are so many cases, would it be okay if I set this on a day, not a Wednesday?
That's fine with us, it's fine with me, Your Honor.
Okay, so, I can actually do 8:30 on November 9th.
Well, Your Honor, I'm going to be in trial in front of you, so that's no problem.
Judge, Judge, I'm not available. We're at a conference at those times.
Okay, what about, I don't have you down for a trial that day.
It's Alan Crystal, Your Honor. That would be the third day of the Alan Crystal trial.
Oh, I only had Alan Christo 2 days, so, okay.
Yeah,
What if,
I know, I'm saying, that's why I said theoretically, yeah.
okay, so if we have Alan Crystal and I'm already holding you hostage, what if we did 8:30 on November 7th? It's a Tuesday.
Are you gone that week, Sam, or is it just the one day?
We're at a conference on the 9th and the 10th.
How about
So are you
the 7th?
available November 7th at 8:30?
What day is it?
It's Tuesday.
Yeah, I typically, yes. Let me look real quick. Yes, I'm available.
Okay, so we will set this for a pre-trial on November 7th at 8:30 in the morning. That way we have a little bit more time to deal with all the files. And Mr. Malaro, Mr. Goldstein, if you can do the stipend order to adjourn on your files. And then Mr. Malaro on the PPO violations, we do the notice of hearing. And then Ms. Adams will make a note to make sure that when you do the waiver of arraignment, it's also set for that day. All right?
Okay, Judge, thank you.
All right, thank you, Mr. Armstrong. You're all set. Thank you, Mr. Goldstein. Was that all you had this morning, Mr. Goldstein? Yep, he's gone.
Yeah.
All right, Mr. Nowak, you have Michael Dagger Margosian, I believe. Yes, okay. So let me get the file.
Your Honor, before the case is called, Ms. Dumont is also going to be on this case. May the three of us, Ms. Dumont, myself, and Mr. Nowak, have a breakout room?
Sure.
Thank you.
Okay. Becky, if the jail could get me Alvin Graves next. All right. So, good morning, Ms. Dumont.
Morning, Judge.
Welcome to my court. All right. I'm going to assign Mr. Dagger Margosian, Mr. Nowak, and Ms. Dumont to a breakout room. Go ahead and join that breakout room. And you are Rhonda Underwood, and she's in front of Judge Olsaver first, okay? Is Rhonda your attorney? Yeah, so she went to Judge Olsaver first. Well, I don't have any defense attorneys. I got Mr. Bain. And I got Miss Van Duzen. All right, so Miss Van Duzen, who are you appearing on behalf of today?
Taylor Theriot.
Taylor Terrio, she is here. They are here. And Mr. Daly, you have Caleb Hutchinson. And who else do you have?
That's it, Judge.
All right, Ms. Terrio, can you hear me?
Yeah, I can now.
Okay. Miss Adams?
Yes, Judge.
Hold on, I'm looking. I don't think I have Terrio. Wow. All right, this is in the matter of, let me find her on my docket.
But I don't see it on the docket. Is it crossed off in the book?
Let me look. I don't see it in my docket either. Hold on.
Your Honor, if I could address the court, our notes indicate a nollie pros was filed yesterday.
Yep. So in the matter of the people of the state of Michigan versus Taylor Terrio, file number 21-202. I think it's a 5-7 FH, Ms. Van Dusen. Mr. Sneed is correct. I show that there was a nollie pros filed in that case.
Okay, we didn't receive notice of it. Thank you.
All right, thank you. So Ms. Terrio, you're all set.
Okay, thank you.
Thank you. All right, Mr. Daly, I'll bring Mr. Hutchison. I also have a Joshua Hutchison. All right, so I have, are you Caleb Hutchison?
Yes, ma'am.
All right, and Ms. Arnold and Mr. Daly, I also have a Joshua Hutchison in my waiting room.
That's my dad.
Okay, I will let him in. All right, so Joshua Hutchison, I'm going to mute you because you're just observing. So this is in the matter of the people of the state of Michigan versus Caleb Hutchison, file number 23-21495 FC. I have James Daly appearing on behalf of Mr. Hutchison, and I have Allison Arnold appearing on behalf of the people. This is the date and time set for pretrial in this matter. Mr. Daly, how would you like to proceed today?
Your Honor, this is the first pretrial, and we believe this matter is going to be resolved. We have not received an offer from the prosecutor yet, but I anticipate that we will. In the meantime, I would just like to set it for trial.
All right, Ms. Arnold.
Judge, I'd ask Mr. Daly if we could, there's events that are taking place in a few weeks that will put us in a position to make an offer. So before we set it for trial, there's no speedy trial concern. I'd ask that we set another pretrial in approximately a month. And then at that date, we could look at setting a trial date. I think at this time, it doesn't make sense yet.
All right, Mr. Daly, any objection for me to set this for a pretrial on November 15th at 8:30?
I think that'll be fine, Your Honor. The record should reflect defendant's out on bond and is doing well on bond, so there's no reason we have to set it for trial today.
Okay, all right, so I will set this for pretrial on November 15th at 8:30 in the morning. Mr. Daly, can you do the stip in order to adjourn?
I will, Your Honor.
All right, very good. So Mr. Hutchison, we will see. I'm sorry, Mr. Hutchison.
Is there a way I can get like a bond condition so I can get a job?
I'm not addressing bond today, so why don't you have a conversation with Mr. Daly, and if he thinks it's appropriate, he can file a motion.
Okay, thank you.
Okay.
Caleb, I will do that.
Okay, all right, very good. Thank you, Mr. Daly.
Thank you.
All right, thank you.
All right, Ms. Dumont and Mr. Dagger Margosian, let me bring, there's Mr. Nowak, let me bring him back. And who do I have with me at the jail?
Graves.
I think I lost Mr. Malaro. So Becky, could you let Mr. Malaro know I have Mr. Graves? All right, we are back on the record in the matter of the people of the state of Michigan versus Timothy Richard Nowak. I have Isaac Sneed appearing on behalf of the people, and I have Michael Dagger Margosian as well as Katrina Dumont appearing on behalf of Mr. Nowak. This is the date and time set for pretrial in this matter. So, Mr. Dagger Margosian and Ms. Dumont, how would you like to proceed today?
Your Honor, this is our first pretrial. What we're requesting is a 3 to 4 week adjournment for another pretrial, and we should have this case resolved by that next court date, if not before.
All right. Are you available November 8th at 8:30 in the morning?
Yes. I don't know if our office is still open that day.
Oh, is that the public defender conference or whatever?
Yeah, but
You're right.
we should be here on the 8th, Judge.
Okay, all right, so I will set this for November 8th at 8:30 in the morning. And Ms. Dumont, can you prepare the stipend order to adjourn?
Yes.
All right, excellent, thank you.
Thank you.
Mr. Dagger Margosian, do you have any other files this morning? You have Jamie Banso and I have.
Yeah, I do have Jamie Banzo, Your Honor.
All right, I have them. All right, are either of you a defendant in the back?
Plaintiff.
Okay. All right, Mr. Banzo, can you hear me?
Yes, ma'am.
All right, this is in the matter of the people of the state of Michigan versus Jamie Ellen Banzo, file number 23-21503FH. I have prosecutor, I'm gonna go with Isaac Sneed appearing on behalf of the people, and Michael Dagger Margosian appearing on behalf of Mr. Banzo. I do show on September 11 a request for preliminary examination. Transcript was filed with the court, and so there's 90 days for that. So October, November, December. So hopefully the transcript will get mid-December. This is for date and time for the first pretrial. So Mr. Dagger Margosian, how would you like to proceed today?
Judge, you read my mind. I don't have the transcript, obviously, and we have to have that to move forward. So I'm just asking for an adjournment past the time of when we'll get it.
All right. Are you available on December 27 at 8:30 in the morning?
Unfortunately not.
How about January 3rd at 8:30 in the morning?
That's fine, Your Honor. Thank you.
All right, so I will set this for January 3rd at 8:30 in the morning. And Mr. Dagger Margosian, can you prepare the stipend order to adjourn?
I will.
All right, so Mr. Banzo, you are all set. And we'll see you back here January 3rd and your bonds continued, all right?
Yes, ma'am. Thank you.
All right. And Mr. Nowak, you're all set too, so you can disconnect as well.
Yes, ma'am. Thank you.
All right, thank you.
Thank you, Your Honor.
Do you have anything else, Mr. Dagger Margosian?
That's it for me. Judge, thanks.
All right, so for a brief moment, I have no defense attorneys. I don't know this. I have someone with the screen name of John S. Can I ask your name, please? Okay, so I do not have audio on you.
I can see the.
Oh, now I have audio. No, I can hear you now. So what is your name, sir?
John Swikert.
All right, yes, okay, so let me change your screen name. And who's your attorney?
Matthews.
Matt Murphy?
Murphy, yeah.
Okay, good. All right, so I'm going to change your screen name and I'm going to put you in the waiting room. And Mr. Murphy is in front of the judge next door. And so as soon as he gets here, I'll bring you back in, okay? All right, so Jess, I'm just gonna put you on hold. Okay, I'm gonna run these files back to Ms. Adams. So we'll take about a 4-minute recess. Yeah.
All right.
Thank you. All right, let's see, you can sit down. Let's see who I got. Got nobody. Well. Becky, do you want to call the first floor of the jail and see if they can get me Mr. Rogers? He's on the first floor.
Okay.
All right, Miss Hines.
Hints.
Hi, oh, Hins, I'm sorry. So Miss Hins, we're just waiting for your attorney and he is next door because he goes to the other court first. So I'm going to add his initials after your name. And then that way I know when he gets here that you're his client, okay?
Okay, thank you, ma'am.
You're welcome. I just didn't want you to think I forgot about you. All right, Mr. McFarland, your attorney is Mr. Malaro, and he is next door in front of Judge Olsager. So I am going to change your screen name so it reflects his initials, and I'll put you back in the waiting room, and when he gets here, I'll bring you in, okay?
All righty, thank you, Your Honor.
Thank you. All right. And we got Mr. Malaro. All right, Mr. Malaro, I do have. Let me get your client's file. This is in the matter of the people of the state of Michigan versus Elvin D. Graves, file number 2023-21428FH. I have Isaac Sneed appearing on behalf of the people. I have Salvatore Malaro appearing on behalf of Mr. Graves. Mr. Coast from Pretrial Services is present here today as well. We arraigned Mr. Graves yesterday, and he had requested a court-appointed attorney on the contempt. And you also represent him on the underlying file and ask for this to be set for today. So, Mr. Malaro, how would you like to proceed today?
Your Honor, may I have a breakout with Mr. Graves? I thought there was there a plea offer?
I don't know.
Oh, Mr. Sneed, is the plea offer still available?
Yes.
Okay. Let me talk.
All right. All right, Mr. Graves, I'm going to open a breakout room. You might have to use the mouse on the computer to click on join breakout room.
Okay, thank you, ma'am.
You're welcome. Okay. All right, let's step off the bench for a moment.
Was called yet or not?
No, you weren't.
No, I
Mr.
wasn't. Okay.
No, your name
I
wasn't.
tried to join the Zoom link, but
Uh-huh.
I couldn't get it to work.
Oh, really? Okay. And sometimes, I think sometimes if you put that number in,
Yeah.
wait until the judge, brings you into the waiting room
Okay.
and she'll ask you for your name. Did you identify your device with your name, Ms. Rose?
I don't know how to do that.
Okay, no problem. Okay, so what she'll do is that once she sees you on there,
Okay.
she'll ask you like she did some of these other people,
Yeah.
and she'll change from the device to the name.
Okay.
So,
Okay, yeah, because I don't know if I got the right numbers or what.
okay, let me check to see, okay?
Yeah.
All right.
All right, you can be seated. All right, Mr. Daggermar goes in. Well, let's see what we got. Nobody in jail. You had NOAC, we handled that. You had Vanzo, we handled that. I don't know why you're here. What do you have?
Your Honor, I'm back on Vanzo. There was I failed to address a bond condition that Mr. Vanzo wants me to address, and I think it would be proper to address it today. So I'm wondering if we can I told him to log back on to see if we could get the case called up for that particular reason.
Yeah, I can do that again, but he hasn't logged on yet, so.
Gotcha. Thank you.
If you group chat John Glazier, Sam Malaro, or Rhonda Underwood, I could get them in and out on one of their cases like in 2 seconds.
All right,
If you're just waiting.
Sure, let me see if I can get them here.
I have Miss Hins, Mr. McFarland, and Mr. Russell. And Mr. Murphy. I have someone for each of those. Oh. Holly. I gotta get that taken down. I just don't hear it. She's a defendant? She's here, but I know her attorney's here. So she just said she tried it earlier, and so she had the right number. Okay. Angelina? Okay. Who's your attorney?
Rhonda Underwood.
Okay, she's next door.
Okay.
Okay. But yeah, you can give that to her. if you want. Josh. You can come up, Ms. Ruiz, just for a minute. This is the Zoom information.
Okay.
You can come in person, you can Zoom, whatever you would like.
Okay. I can still join the Zoom then and wait. Yeah, I can go home then. Is that okay?
You can.
Okay, or is it just?
As long as you're not like an hour away.
Yeah, no, just 5 minutes.
Okay, yeah, you're fine.
All right, thank you.
Thank you. Right, your client is still not logged in yet, Mr. Gagnon.
Okay, he says he's in there, but maybe he's still working on it.
He might have logged in, it's just connecting. There he is, got him. Ms. Adams, I'm sorry, could I get the Vanzo file back, please?
Okay.
Right. Mr. Sneed, are you on Vanzo?
I'll cover, Judge, yes.
All right, this is in the matter of the people of the state of Michigan versus Jamie Allen Vanzo, file number 23-21503FH. I have Isaac Sneed appearing on behalf of the people. I have Michael Dagger-Margosian appearing on behalf of the defendant. I do show, I think Ms. Muir has this file, but I think she's out this week. So Mr. Dagger-Margosian, we've already addressed this file, but you're bringing it back to address bond.
Your Honor, I am, and I don't want to catch anybody off guard here. I did have in my notes that I would address this. I just failed to mention it on the record earlier this morning when it was called. But the single issue I want the court to address, or I'd ask the court to address, is under the bond conditions that were given in district court. There's obviously no contacts with the alleged victim, but there's also, I don't really know why, but there's a no contact with anyone under the age of 18. Mr. Vanzo has children. He hasn't been able to see them, particularly due to that bond condition. But more generally, I just don't know if that bond condition is specific or tailored towards this case. This is the allegation itself is from 6 or 7 years ago. He has no prior criminal history, to my knowledge, certainly nothing to this magnitude. So I would just ask the court to dismiss that bond condition. Additionally, he's been on bond for, a period of time here and there's been no violations. So that's my request this time.
Right, so I show that he was arraigned in August of this year, so looks like he's only been in the criminal justice system for a couple months. The charges are criminal sexual conduct, second degree, alleging sexual contact with an individual under the age of 13, and there's 2 counts. And it looks like a preliminary exam was held. Ms. Adams, I do not show that we have a TCN on him, nor do I see an order for fingerprints.
Yes, Judge, we are taking a different route, trying to remedy that.
Okay, and this is a Madison Township case. Should I instruct him to contact Madison Township fingerprints?
If they have not been done, we'll send a new order.
Okay. All right. So, Mr. Sneed, I recognize that you're not on this file, but are you able to address bond?
Your Honor, the people would oppose the request, without some additional information. I don't think we're in a position to respond today, since it wasn't made without a written motion. But if counsel wanted to file a written motion, we certainly would respond with greater details. I'm reviewing the police report. It looks like these were girls, again, under the age of 13. So, without more information, I don't think we're in a position.
So, Mr. Degemarkosian,
serious bond condition today. Thank you.
Ms. Mears not available today on this file, and Mr. Sneed's, obviously is not familiar with this file. So I would ask that you file a motion, or, we could hear it within a short period of time, but perhaps file the motion. Other than the felony information, I have no information on this file, so I can't really make an educated decision about it. So if you'd like to file a motion and schedule it with my court, we'll try to get you in as soon as possible. It probably won't be a Wednesday, but.
Okay.
Okay.
Thank you, Honor.
All right. All right. Thank you, Mr. Banzo. You're all set.
Thank you very much. Appreciate it.
Thank you. All right, Mr. Malaro, we are back. And I think I have, let me double check this. MDOC's been having problems. Hi, I have somebody who's called it on a direct telephone number. Who is this?
Yes, this would be Sergeant Mega from Carson City Corrects Facility. I'm calling with, hold on, I gotta find his name. Offender Jackson 162043, is this correct?
Derek Jackson?
Yeah.
Okay.
So I'm gonna transfer you to his extension.
Okay, great. Thank you.
I just wanted to make sure that it was you guys. All right, one moment.
Okay, thank you.
The free security app, only for Michigan residents. Michigan Secure helps protect you from unsecured.
Hello.
Hi, Mr. Jackson.
Yeah.
Hi, this is Judge Anna Marie Anzalone from Lenawee County. So one of the employees of MDOC, evidently they weren't able to connect to Zoom. So they called in on a direct telephone number to me. So you are in the courtroom over microphone, and we are waiting for your attorney. You are represented by John Glazier. So as soon as he gets here, we will take you first, okay?
How did I get a attorney? I ain't even talked to the man.
Right, and I will be able to provide you a way to speak with him this morning, okay?
And I'm going to trial right now too.
No, it's just a pre-trial today. So, all right, so I'm going to put you on hold, and it might be a few minutes until Mr. Glazier gets here. He's next door, okay?
Yes, ma'am.
All right, thank you, Mr. Jackson. I'm putting you in the waiting room. Okay, so Mr. Malaro, we are back on the record in the matter, the people of the state of Michigan versus Alvin D. Graves. Have you had an opportunity to speak with your client, Mr. Malaro?
I have, Your Honor.
And Mr. Malaro, how would you like to proceed today on behalf of Mr. Graves?
Your Honor, I will need more time to review the plea offer with Mr. Graves. The plea offer is an attempted possession, there are no supplements. I don't think Mr. Graves has any prior felonies from what I can see. But I do need to review it with him in depth, given his unfamiliarity with felony cases. So we would ask to adjourn the pretrial for a further pretrial to do that. I certainly understand if we work this out ahead of time, we can bring him in for the plea. But Mr. Graves.
So I can set this for October 18th. Would that give you enough time to meet with them? And that's only 2 weeks out.
Yeah, Judge, either way, he does intend to plead guilty to the contempt charges.
Okay.
We'd be asking to address his situation of in custody.
Okay, so on the underlying file, you're requesting a pretrial conference, and would October 18th be too soon, or?
Either way, Judge, it would be fine as long as that's a Wednesday, I presume, so.
Yes. All right. So for the pretrial, we'll set that over to October 18th at 8:30 in the morning. And you're saying that he wishes to address the contempt of courts today?
Yes.
All right. So, Mr. Graves, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, so Mr. Graves, we were here today on a pretrial under underlying charge, which is controlled substance, possession of methamphetamine. And then you also have a number of contempt of courts. Do you understand that?
Yes, ma'am.
Now, contempt of court carries a maximum penalty of up to 93 days in jail and or a $7,500 fine. Do you understand that?
Yes, ma'am.
And do you understand that you had requested court-appointed counsel and we appointed Mr. Milaro on the contempt as well? Are you satisfied with Mr. Milaro as your attorney and the advice that he has given you?
Yes, ma'am.
All right. Do you understand that you do have a right to contest the contempt of court and to have a hearing on it?
Yes, ma'am.
Do you understand that throughout that hearing, you would be presumed innocent until your guilt is proven beyond a reasonable doubt? Do you understand that?
Yes, ma'am.
You have a right to have all the witnesses appear against you, to have your lawyer ask those witnesses questions, to ask those witnesses questions yourself, and to have me order any witnesses you might have to appear at the trial. Do you understand all of that?
Yes, ma'am.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, ma'am.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes, ma'am.
All right, so Mr. Graves, we have, let me go back here. We have a motion. All right, so we have a motion affidavit and bench warrant that was filed and received by the court on September 1 of 2023, stating that you failed to report to pretrial services coordinator Darren Coast on August 31 of 2023 at 8 a.m. for a drug screen as directed by Judge Anselmo, me, and that you had missed your prior 3 drug screens and you were refusing to, or not answering the phone calls that you were receiving from Mr. Coast. Do you understand those are the allegations against you?
Yes, ma'am.
Now, we also have a contempt of court for failure to drug test on August 18, August 21 at the Lenawee drug testing facility as ordered as well. Do you understand that?
Yes, ma'am.
All right. And Mr. Graves, is it your intention to plead guilty to those contempt of courts?
Yes, ma'am.
All right. So how do you plead to the charge that you violated your bond conditions by failing to test as ordered on August, get back there, August. So August 18th and August 21, guilty or not guilty?
Guilty.
And how do you plead to the charge that you failed to report as directed by this court to Darren Coast on August 31 at 8 a.m. for a drug screen?
Guilty.
Okay. Has anything been promised you to get you to plead guilty?
No.
Has anyone threatened you in any way to get you to plead guilty?
No.
Do you understand if you plead guilty, you're giving up your right to a trial, as I've already explained to you?
Yes.
All right. If I accept this plea, you'll be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, ma'am.
And it's your own choice to plead guilty.
Yes, ma'am.
All right. So, Mr. Graves, we were here in court not too long ago, and I had a letter from Darren Coast stating that you had missed 3 consecutive drug screens, and you were asked to report on August 31 at 8 a.m. for a drug test. Do you remember that?
Yes, ma'am.
All right. Did you report the next morning or August 31 at 8 a.m. for a drug test?
No, ma'am.
And did you miss your drug test on August 18?
Yes, ma'am.
And did you miss 3 prior drug screens as well?
Yes, ma'am.
And did you contact Mr. Coast to schedule those or talk to him about it?
No, ma'am.
Okay, why not?
I get scared and I get stuck in my head and I run away from my problems instead of trying to fix them. I really need to work on
Okay.
them.
Was it because you would have been dirty?
For weed, yes.
Well, most people aren't worried about weed because it's legal now, but
I know.
would you have been dirty for anything else?
I have not, ma'am.
You don't know. Okay. All right. Accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights and he does have competent counsel. Mr. Malaro, is there anything you'd like to say on behalf of your client before the court passes sentence?
I would, Judge. Mr. Graves reports he's employed at Hilex. He had just started about 10 days ago, so he has not had an opportunity to get a paycheck yet. He was released, I think, on the 30th of August. So getting a job within 3 weeks, I think, is actually a good sign. Since he had been in custody for a fair amount of time, he wouldn't have had the funds to test. What he just told you is consistent with what he explained to me when I spoke with him, that he would be positive for weed. I, without representing the court, told him that that's typically not the court's main concern. I also explained to him that if he doesn't have the funds to test, he should still appear and let the testing center determine whether or not they'll issue him credit. I also explained that Mr. Coase is sometimes, if not more often than not, willing to try and find a solution, but if he's not there, he can't help him, and or to call our office, because that's sort of what I get paid to do. That, considering all that, Your Honor, and the fact that this is such a recent the time frame is so recent from his employment, I'd ask the court to consider a small fine, let him be released so he could get back to work. I did review the plea offer, but it's something that needs to be done, I think, on a more personal level, because he does not have, the experienced understanding of the felony system like some of our other clients do. So that would be a request of this court with respect to the underlying felony and the contempt charge.
Mr. Sneed, do you wish to weigh in at all?
No, thank you, Judge. We defer to the court.
All right. Mr. Graves, is there anything you'd like to say on your own behalf?
No, actually, ma'am, there's not.
All right. Mr. Graves, do you understand failure to follow through with things gets you jail time, right?
Yeah, I do now.
Okay, and that you lose all control over whether you get to show up or not, because if you don't, I can put you in jail. You got that?
I got that.
So you were ordered twice now to do things and you failed to do them. So tell me why I should let you out today.
Man, I've been working really hard at trying to get a job and keep my job. I haven't so much thought about courts like I should have been, more than just thinking about getting a job and making sure my son had money, making sure I had money, so that way when things went wrong, I was stable. I really there's just a lot going on in my life right now. It's a headache that I know I've got to deal with, but I know now that the courts are more important than my job, because if I don't do you guys, I ain't gonna be able to keep my job. And
no. And you're here in a meth case, so if you're using meth, you're not taking care of your kid or yourself, right?
Right.
Thank you then. Please go ahead and log in.
All right, Mr. Coast. Mr. Coast, you want to mute yourself? Okay. All right, so Mr. Graves, I'm going to require you to, what's your work schedule at work?
I work from 2 o'clock in the afternoon. 3 o'clock in the afternoon to 2 o'clock in the morning, Monday through Sunday.
Okay. So, Mr. Graves, I am going to require you to report in person to Mr. Coast every week. Do you understand that?
Every week.
Mr. Coast, what day and what time?
Judge, we could do Monday right at 8 o'clock.
Perfect.
All right. So you're going to have to report every Monday at 8 a.m. to Mr. Coast. You're going to drug test as directed and required on your bond conditions. If you miss one, if you fail to report one time, I will issue a bench warrant and you will not be getting out of jail.
Yes, ma'am.
Do you have any questions?
I have none.
All right. So I'll release you on a PR bond and I will set sentencing on the contempt of courts for October 18th at 8:30 in the morning.
Okay.
And you will get out today. Do you want to just next Monday, Mr. Coast?
Judge, I'll actually like to see him today because, I want to make sure that he's has his color card. He also mentioned that he takes prescriptions. I never received those prescriptions, so I do need to see him today.
Okay. So when you get out of jail, you will walk across the street and you're going to come to the courthouse. You're going to go to the 3rd floor. You're going to report to the clerk's office. You're going to say, I'm here to see Mr. Coast. All right. If you don't do that, I'll issue a bench warrant. Got it?
I'll be there.
Okay. All right. You're all set. Thank you, sir.
Thank you, Judge.
And Mr. Malaro, you'll do the stipend order to adjourn the pretrial.
I will, Your Honor.
Mr. Russell, come on up and I'll get you out of here. I think we're getting old, Mr. Russell. We don't get up as quick as we used to, right? All right, Miss Underwood, Mr. Russell, I'm going to take him first because he's been here this morning. So this is in the matter of the people of the state of Michigan versus Milton Dwayne Russell, file number 23-21337FH. I am Rhonda Underwood appearing on behalf of Mr. Russell. And I have Allison Arnold appearing on behalf of the people. This is the date and time set for pretrial. So Miss Underwood, how would you like to proceed today on behalf of Mr. Russell?
Your Honor, I apologize. Mr. Russell and I could not connect. So I need just a brief breakout with him.
Okay, so Mr. Russell, do you know how to use the Zoom device in the hallway?
I used it one time when I was here last
Okay,
time.
so Miss Adams, could you or Miss McRain connect the Zoom in the hallway for Mr. Russell? All right, so just go on out there to the left and they'll connect you. All right, Mr. Glazier, I have Derek Jackson from the Michigan Department of Corrections. Mr. Jackson, for whatever reason, they weren't able to connect to Zoom today. So he called in on the Zoom telephone number. And he's going to want to talk to you. So would you like to take Ruth Hins first?
Yes.
Okay. Mr. Jackson might be a while. All right. And who represents Miss Ruiz, Angelita Ruiz?
I do,
Okay.
Your Honor.
Okay. All right, I got the hallway. I'm gonna bring the hallway in. All right, the hallway needs to connect to audio. Miss Adams, the hallway is not connected to audio. Miss McGrain or Miss Adams? She's going back out. Yes. Hold on, Miss Hins. There we go. All right, so I'm going to open up a breakout room. And I'm going to put Miss Underwood and Mr. Russell into that breakout room. All right, so Mr. Russell, just click on, tap join breakout room. All right. All right. Okay, so Miss Hins, so this is in the matter of the people of the state of Michigan versus Ruth Romaine Hins, file number 23-21402-H. I have John Glazier appearing on behalf of Miss Hins, and I have Isaac Sneed appearing on behalf of the people. This is date and time scheduled for pretrial in this matter. Mr. Glazier, how would you like to proceed today?
Your Honor, I'd ask to adjourn this out maybe 60 days. I've talked to Mr. Sneed about this. There's a couple of transcripts from depositions in a civil matter related to this case that I want to get copies of. And I told Mr. Sneed I would get those and send him copies. They have not been typed up yet, but the depositions have occurred.
Okay, so how far out?
I'm thinking 60 days at the most.
Okay, so what about December 13 at 8:30 in the morning?
That's fine, Your Honor. That's my brother's birthday.
Well, bring us cupcakes. All right, so December 13 at 8:30 in the morning. And Mr. Glazier, can you do the step in order to adjourn? Mr. Sneed, can you sign your name with permission?
Yes, Judge.
All right. So Ms. Hins, you're all set. Thank you.
Thank
I'm sorry, that was December 13th, right?
Yes, ma'am, at 8:30.
Okay, thank you very much. You all have a wonderful day.
Thank you.
Thank you.
All right, can't take it. All right, so Ms. Underwood, I have Mr. Russell back. So how would you like to proceed with Mr. Russell today?
Your Honor, Mr. Russell would like to accept the prosecution's offer of an OWI second offense with the felony being dismissed, Your Honor.
Okay.
I'm gonna have to have time. I need that offer has been made. We need to get an amended information and a plea form. I can go off the record and do that. I'm also on Ryan Pontius and Derek Jackson, if the court wants to pass those till I'm back.
So hold on a second, Ms. Arnold. So we're going to be adding account 3. What are we adding?
Operating while intoxicated, second offense.
And that would be account 3, correct?
Correct.
And that carries, I mean, I don't need you to amend it right this second, as long as it's done today. I don't usually require having the amended in hand before I take the plea. Is that all right with you? Is it just delays?
Yeah, that's fine, Judge. I can pull up the charging language.
All right, so an OWI second carries a maximum penalty of up to 1 year in jail, and the license suspension would be what, Ms. Underwood and Ms. Arnold?
Just give me 1 second, Judge. I'll pull up the charging language.
This is the one we had the bench conference on, Ms. Underwood?
It is, Your Honor.
And the DW, the operating with license suspended is nolly crossed then as well as count 1, Ms. Underwood?
I believe so, Your Honor.
Hang on 1 second, Judge. I just want to confirm that's the offer. Yeah, okay. So the OWI second offense notice, I can read the penalty language into the record for the court.
Yes.
It's a misdemeanor punishable by a fine of $200 or up to $1,000 and 5 days to 1 year in jail, or 30 to 90 days community service, or both, and rehabilitative programs. Cost of prosecution apply, has to reimburse the government for emergency response and expenses for prosecuting the defendant, and vehicle immobilization is mandatory.
Do you understand all that, Mr. Russell?
I caught most of it.
I can read it again. Let me read it one more time.
So one more time.
Since he doesn't have a written document in front of him and hasn't signed a written plea form. All right, it's a misdemeanor punishable by a fine of up to $200 or $200 up to $1,000 and 5 days to 1 year in jail, or 30 to 90 days community service, or both, and rehabilitative programs. Cost of prosecution apply, as well as reimbursing the government for emergency response and expenses for prosecuting the defendant, and vehicle immobilization is mandatory.
Do you understand all
Yes.
that? Okay. All right. So
Person thought there was 2 separate fines. She said the 200 and 1,000.
there's court costs.
Yeah,
there's-
so it can range up from
It can range
200
there,
to
and
1,000.
it's up to
Okay.
my discretion.
Okay,
Okay.
yes, yeah.
All right. So, Mr. Russell, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. So, Mr. Russell, have you heard the statement of your attorney as well as Ms. Arnold, the prosecutor? Is it your intention then to plead to an added count 3, operating while intoxicated second offense?
Yes.
And Ms. Arnold eloquently read off all the penalties, so you fully understand all of those.
The fines, the 5 days in jail up to a year.
Community service,
Community service.
vehicle immobilization. Do you have a car?
No.
Okay.
And community service. Up to service goes up to a year in jail, and I don't know how long. I didn't recognize like how long I was trying to for like the.
So you can get a jail term of 5 days to up to 1 year, and then Ms. Arnold, the language is also or community service, correct?
Yes, Your Honor.
Okay. Yes.
And that your attorney will argue for at the time of sentence.
Okay.
Okay. Have any questions about that?
No, I don't.
So it is your intention then to plead guilty to that charge?
Yes.
Okay. Are you satisfied with Ms. Underwood as your attorney and the advice that she has given?
Yes, sir.
Neither, other than the plea offer, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed what an actual sentence would be. Is that correct, Ms. Underwood?
It is, Your Honor.
And Ms. Arnold?
Yes, Your Honor.
And is that correct as far as you're aware, Mr. Russell? If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at a trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial. And if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you had been convicted at trial? You understand that?
Yes, sir.
All right. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? So if you've been convicted at trial, you have an automatic right for appeal. But if you enter a plea, you have to petition for that. Do you understand that?
Yes.
All right. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given you today? All right. So, Mr. Russell, how do you wish to plead to the charge that on or about March 29 of 2023 in the city of Adrian in the county of Lenawee that you did commit the offense of operating while intoxicated, second offense, guilty or not guilty? Has anyone made any threats or promises to you to induce you to plead guilty to this charge? Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
And Ms. Arnold?
No, Your Honor.
All right, so Mr. Russell, other than what was placed on the record, has your attorney promised you any particular sentence or estimated what your sentence will be? Is it your own choice to plead guilty?
Yes, it is.
All right, so Mr. Russell, back on March 29th of 2023, were you operating a motor vehicle in the city of Adrian in the county of Lenawee?
Yes, sir.
You were actually driving on Winter Street, is that correct?
Yes, sir.
And had you been consuming alcohol?
Yes, sir.
Was it beer, wine?
It was alcohol. I think it was.
So liquor?
Yes.
Okay. And would you agree that you had an alcohol content of 0.08 or higher?
Probably so, yeah.
Okay. Do we have a BAC or a PBT or anything, Ms. Arnold or Ms. Underwood?
It's breath, so it would be 0.08 grams or more per 210 liters of breath.
Okay. And would you agree that was the limit at which you weren't supposed to operate a motor vehicle?
Yes, sir.
Okay. All right. Ms. Arnold, anything further?
Just to make the record clear, Mr. Russell, your breath alcohol content exceeded 0.08 grams per 210 liters of breath. Is that correct?
It probably did. I don't remember the exact breathalyzer, but I'm saying probably so, yes. I
Hang
don't remember the exact.
on.
I don't remember.
Ms. Underwood, is the PBT in the police report or?
I'm saying
going
yes.
to the police
It's
report right now.
obviously that it did. I just can't recall the exact number, so I don't want to say that it, you know what I mean?
Okay. Well,
So yes, I do agree that it did.
Okay.
I'm satisfied.
Okay. Has the court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has, Your Honor.
Ms. Arnold?
Yes, Your Honor.
Right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case for the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the district court probation for a pre-sentence investigation. Because it's a misdemeanor, you'll be on district court probation.
Okay.
All right. Do you know how to get an alcohol assessment?
I'm in alcohol treatment as we.
Are you right now?
Yes,
Excellent.
I've been going for a while, yes.
Good. All right, so,
I go to McCullough from Vargas.
okay. So if you ask them for an assessment, they'll be able to provide that to me.
Okay.
Okay?
Yes.
All right, so I'm going to refer this matter, as I said, to the District Court Probation Department for a pre-sentence investigation. So not tomorrow, but the following week, I need you to report to District Court Probation in the morning. And
Following Thursday?
like a week from tomorrow. So it would be,
Following Thursday?
yeah, so it'd be October 12th. Okay, and check in with Mike McCarron, the probation officer there, and he'll do the report for me. So be truthful with them about your background, the events that occurred, meet with them. He'll make a recommendation. And then, Ms. Underwood, are you available for sentencing on December 1 at 8:15 in the morning?
That's fine, Your Honor.
So I'm going, Ms. Adams, can I get a notice of hearing from Mr. Russell? So I will set this for sentencing on 12/1 at 8:15 in the morning. So you can come in person or you can appear via Zoom. How would you like to do that?
It's easier, the Zoom is kind of confusing.
That's okay. So we'll mark that down in person. And Ms. Adams is going to get you a notice. So just have a seat right there and we'll get you a notice. All right. All right. Thank you, Mr. Russell. All right. And Ms. Arnold, and that's fine. Just today, the amended information. Thank you.
We will, thanks.
All right. Mr. Glazier, I'm going to bring in Mr. Jackson. Mr. Jackson, can you hear me?
Yeah, I can hear you.
Okay, good. So this is in the matter of the people of the state of Michigan versus Derek Anthony Jackson, file number 21-20643FH. I have John Glazier here today. So Mr. Glazier, this is a file that the matter should be either set for retrial or negotiations. He has requested reassignment through the public defender's office. So Mr. Glazier, who is the public defender that is assigned to represent him? You're muted, Mr. Glazier.
I'm handling this case as of right now.
All right, Mr. Glazier, Mr. Jackson, I brought him in earlier and got his name and information. He would like a breakout room with you. Do you have time to speak with him this morning?
I do, Your Honor. I hesitate to do it just by phone, but I will at this point for now.
Okay, so Mr. Jackson, we set today so that we could have an assigned attorney for you, and that is Mr. Glazier. So this is his first appearance with you. So in the future, he'll also meet with you, but I will open up a breakout room and put both of you in that, okay?
Yeah.
And because you're on a phone, you'll just automatically go, and then I will automatically bring you back in when you're done, when Mr. Glazier comes back, okay?
Yeah.
Okay, so let me find you. All right, so Mr. Glazier. Okay. All right, I'm gonna open that breakout room and he is in there. All right, so I have Miss Adams, my jail window's been empty a long time. So I have Briggs. So I do have Miss Underwood and Mr. Malaro. So I'm ready for Emily Smith and Jason Opal. Those are Rhonda Underwood's files.
I don't believe Smith is mine, but do we have Ms. Ruiz, Your Honor?
Yeah, she's been here all morning and she just walked out. She is moved in.
I apologize. I was in the other court.
Well, we all know that you like Judge Olsaver better, so I've accepted it. I said, we all know that you like Judge Olsaver better, so I've accepted it.
That is not true.
So you're saying you like me better than Judge Olsaver?
I profoundly like you both, Your Honor.
Okay, all right, Miss Ruiz is connecting to audio, so let me get her connected. There we go. All right, this is in the matter of the people of the state of Michigan versus Angelita Anna Ruiz, file number 23-21538FH. Miss Ruiz, going forward, that's always the same Zoom number for me. I have Rhonda Underwood appearing on behalf of Miss Ruiz, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for arraignment in this matter. Miss Underwood, do you waive the reading of the felony information?
I do, Your Honor.
Have you received a copy of the prosecutor's request for discovery and witness list and felony information?
I do, Your Honor.
And how would you like to proceed today on behalf of Ms. Ruiz?
We would ask the court to enter a not guilty plea on Ms. Ruiz's behalf and set this matter for trial. And set this matter for a pretrial.
How far out would you like a pretrial?
Probably a month or 6 weeks, Your Honor, would be good.
How about November 15 at 8:30 in the morning?
Thank you, Your Honor.
All right, so Ms. Ruiz, your next pretrial is going to be November 15 at 8:30 in the morning. You can Zoom in or you can come in person. It's really whatever you're more comfortable with, all right?
Okay, yep.
And because it's an arraignment, my staff will prepare the notice of hearing. Thank you, Ms. Underwood.
All right, thank you.
All right, and Ms. Ruiz, you're all set. You can disconnect. Mr. Glazier, I'm going to bring back Mr. Jackson. Mr. Malaro, do you need to speak with Zachary McFarland this morning before we call the case?
I do not, Your Honor.
All right, so Mr. Glazier, we are on the record in the matter of the people of the state of Michigan versus Derek Anthony Jackson, file number 21-20643FH. Mr. Glazier, how would you like to proceed today?
Your Honor, we'd ask to adjourn this for just a couple of weeks. I need to speak with his appellate counsel, evidently.
Okay, so I will set this to, are you available November 1 at 8:30 in the morning?
That's fine, Your Honor.
All right, so Mr. Jackson, we will set this out to November 1 at 8:30 in the morning. We will do a writ for MDOC. And hopefully the next time they'll be able to connect you with Zoom, okay?
Yeah.
All right, so we'll see you back for pretrial November 1 at 8:30. And Mr. Glazier, you'll prepare the stipend order?
Yes, Your Honor.
All right, so you're all set, Mr. Jackson. Thank you.
Yep.
That's all I have with you, Your Honor. Thank you.
All right, thank you. Who do I have from the jail, please?
Daniel Kennedy.
What is your name?
Daniel Kennedy.
Spell your last name.
CANADY.
Judge, that's an Olsaver case?
Okay, so tell them that you're in the wrong court.
Okay, thank you.
That you're Judge Olsaver. Thank you.
Okay.
So, Mr. Malaro, I have Mr. McFarland. Grab his file. This is in the matter of the people of the state of Michigan versus Zachary Michael McFarland, file number 22-21053FH. I have Salvatore Malaro appearing on behalf of Mr. McFarland, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a final pretrial conference. We are scheduled for trial on October 19th of 23, and they very well are probably across the hall, but just as a reminder, this is the date and time set for a motion deadline. And then jury instructions and voir dire questions were due September 27. I do have, hold on a second. On August 4, Mr. Malaro, you filed an objection to the prosecutor's proposed voir dire. Objection to their jury instructions. And Mr. Malaro, your office has filed your voir dire questions and jury instructions.
But we did not have any proposed jury instructions and or voir dire questions. We did file an exhibit list, and we did issue a subpoena for, I think, the trooper.
Okay.
And I think the trooper has been served.
Okay. So we do have these objections to deal with, and I do not want to do that the day of trial. So if we're scheduled for trial October 19th, I'm going to set a time, and Mr. McFarland, it'll be kind of like a bench conference, or we could do it on the record to go over the jury instructions and voir dire questions that are in dispute. So, do you want that to be a formal hearing, Mr. Malaro, Mr. Sneed, or just a bench conference?
Judge, I think a bench conference would be fine.
All right, so Mr. Malaro and Mr. Sneed, are you available anytime at all, October 17th of this year?
Judge, this is Ms. Mears' file, but if Mr.
It is,
Sneed
and she
wants
is available.
You said October 17th?
Yes, what would be a good time for you, Mr. Malaro?
I'm pulling up the date right now. Oh. Sorry.
A bond hearing at 8:30. I don't have anything at 9:30.
Judge, I have a prelim at 10.
Okay, what about,
So before that would be fine. Before that, 10
how
o'clock.
about 9 o'clock? 9 o'clock?
Yeah, 9 would be good.
Mr. Steed, is Ms. Mears' calendar open?
Yes, it is, Judge. Thank you.
Okay, so I'm going to set this for a bench conference. It will be in person because I need to shuffle paperwork with you guys. So we'll finalize the jury instruction book. Let's see. Probably only need about a half hour. So it's going to be in person. And Ms. Adams, if we can produce just a generated notice of hearing for this bench conference, Tuesday, October 17th at 9 a.m. And is there anything else we need to address today?
I don't think today, Judge. I think we're fine with that.
Okay, all witnesses have been served?
On our end, our witnesses, yes.
Okay. All right, so Mr. Malaro and Mr. McFarland, do you want your client here that day as well or no?
Yeah, Zach, is that okay for that date? Can you be here?
October 17th at 9 o'clock.
Yeah.
Yeah, I could be there.
Okay.
Okay,
Yeah,
excellent.
I'll be here.
All right, and then other than that, we will continue to trial on October 19th at 9 a.m. All right, very good. Thank you all.
Thank you, Judge.
All right, Mr. Malaro, don't go anywhere.
I won't.
Something else with you? So, Mr. Malaro, we have Emily Smith. She's on the second floor.
Correct.
I have Rhonda Underwood on Jason Opal and Angelica Contreras. So we'll just see who shows up. Mr. Murphy, I do have Mr. Schweikert.
Your Honor, could I speak with him, please?
Sure. Mr. Schweikert, can you hear me?
Yes.
All right, this is in the matter of the people of the state of Michigan versus John Lewis Schweikert, file number 2023-21496FH. I have Isaac Sneed appearing on behalf of the people, and I have Matt Murphy appearing on behalf of Mr. Schweikert. Mr. Schweikert, your attorney would like a breakout room with you. So what I'm going to do is send you an invitation to join a breakout room. You're going to tap it if you're on a tablet or a phone, or you're going to use a mouse if you're on a computer, and then just join that breakout room, talk to Mr. Murphy. Some people get confused leaving it, so just stay in there, and when Mr. Murphy comes back, I'll close the room and bring you back, okay?
I'll try.
All right. Okay, good. So I'm sending you an invitation. Do you see it?
Yes. I
Good.
put.
Go ahead and click on join. Yep, click on join. All right, who do I have from the jail, please?
Emily Smith.
I have, yep, with a mask. What's your name, please?
Emily Smith.
All right, so Ms. Smith, let me grab your file. That is Mr. Malaro. So this is in the matter of the people of the state of Michigan versus Emily Ann Marie Smith. We have two files, 22-21177FH and 23-21352FH. So Mr. Malaro, let me find her on my docket. We are here on file number 22-21177FH on a show cause for failure to pay fines, costs, and fees in equal monthly payments. So that is this a violation of probation? No, this is during post. So this must have been a deferred.
Correct, Judge. You put her on for 12 months to where she's supposed to be fines and costs on that, and nothing's been paid.
Okay, so that's technically a probation violation / bond violation. And then on file number 23-21352FH, I have a pretrial on a contempt of court, and on the original file and the allegation, we have a motion, affidavit, and bench warrant that she tested positive for meth from swabs on June 5, June 12, June 16 of this year, and then she failed the test on June 19, June 23rd, and June 26th as directed. So Mr. Malaro, this is also the underlying criminal file as well for pretrial. Mr. Malaro, how would you like to proceed today on behalf of Ms. Smith?
We have a breakout with Ms. Smith, Your Honor.
You may. So Ms. Smith, I am going to, just a second, put you in a breakout room. Hold on, I have to close this other one. All right, so I'm going to put you in a breakout room with Mr. Malaro, and you should, because you're on a Polycom, go automatically. There you go. Oh, she's gone. All right, so we are back on the record in the matter of the people of the state of Michigan versus John Lewis Schweikert. Mr. Murphy, have you had an opportunity to speak with your client?
Yes, Your Honor, thank you. I was going to ask if we could set another pretrial on this matter, if Mr. Sneed wouldn't object to that. I just wanted to discuss things further with him and with my client and see if we could get to a resolution short of trial in this matter.
All right, how far out would you like retrial?
Whatever fits the court schedule best. I won't need more than a few weeks, but whatever fits the court schedule best.
So my next available, how about November 8th at 8:30 in the morning?
That worked for the defense, Your Honor. Thank you.
All right, and Mr. Murphy, you'll prepare the stip in order to adjourn?
Yes, Your Honor.
Mr. Sneed, you can sign your name with permission?
Yes, thank you.
All right, so Mr. Schweikert, your next court date is November 8th at 8:30 in the morning. But you need to make sure to contact Mr. Murphy before that to talk about the case, okay?
Yes,
All right, very good. You're all set, Mr. Schweikert. Thank you.
thank you.
Thank you, Mr. Schweikert. Have a good day, okay?
Yes.
Okay, and I'm just gonna disconnect you now because it's always hard to get out of here. All right, Miss Underwood, let's see what we got here. Still waiting for jail. All right, so Miss Underwood, I have Josh Kimbrough, but I don't think you're on that yet, or are you? Nope. All right, so this is in the matter of the people of the state of Michigan versus Josh Allen Kimbrough, file number 2020-20162FH. We provided a request and summons for probation violation, which was mailed to Mr. Kimbrough's last known address. The allegation is he failed to report to probation upon release from jail on September 4 of 2023, and his whereabouts are unknown. He has failed to appear, so I'm going to issue a bench warrant for his arrest. Miss Holly, what is the balance owed on his arrearage?
Oh, I'd have to check on that. Last I knew, it was over $16,000.
Okay, so I will set bond in the amount of 16,000 cash, and I'm sure we'll find it at some point. Thank you. All right, so Barton Blake, Kentucky Court hearing. All right, this. No, prejudgment. Okay. Ms. Underwood, I think that all we have left are people in custody. And then Ms. Contreras is set at 11. So I'm gonna call the jail. Hi, this is Judge Anzalone. How are you today?
Good, how are you?
I am good. Would it be possible for me to get Jason Opal? I know I have an open window on the second floor.
I've called for about 4 times. We'll see if we can speed it up a bit.
Okay, thank you so much.
No problem, bye.
Bye-bye. All right, Ms. Underwood. Just waiting for your peoples. You want to take a quick break, you can, and I'm going to walk these files back to Ms. Adams. Ms. Speed, if you need to take a quick recess, you can.
Thank you, Judge.
Told her I was gonna issue an LAO that court staff aren't allowed to have face and neck tattoos. Aren't allowed to what? Face and neck. Oh. Oh. All right, so. I don't know, buddy. Yeah, Mr. Murphy now. Hey, this is Judge Anzalone again. If Mr. Opal doesn't want to join us today, I do have an attorney who's here now on Madison and Bowerman.
Okay, let me call. Now,
Okay, thank you. Bye-bye.
Your Honor, what's the problem with Mr. Opal?
I don't know that there's a problem with Mr. Opal, or I just can't get people right now from the jail. I don't know.
Oh, okay, because I didn't think there was, but okay.
Well, it's early. He might be tired. It might be transport. You never know. Could be anything.
I don't have an offer on the underlying charge. So you're gonna admit to that paying for money?
Judge, that was Joanne Holly on Kimball, right?
That's what?
That was Joanne Holly.
Joanne Holly's the MDOC.
Oh, is she? Okay, well,
I don't know that we normally put that in.
oh, don't you? Okay,
I don't think we don't, because they're not a county employee.
okay,
So I don't think we actually list the
okay,
probation officers, but I don't know.
okay.
Becky?
But that was her, wasn't it, on Kimball?
Yeah, Judge, I think,
Go ahead.
I was gonna say, I think they do put who's present on it.
Oh, from the probation? Okay. All right, so who do I have joining me from the jail?
Jason Opal.
All right, Mr. Opal, let me grab your file. This is in the matter of the people of the state of Michigan versus Jason Frank Opal, file number 23-21508FH. I have Rhonda Underwood appearing on behalf of Mr. Opal. Miss Underwood, and I have Isaac Sneed appearing on behalf of the people. this is the date and time set for arraignment in this matter, Ms. Underwood. So do you waive the reading of the information?
I do, Your Honor.
Have you received a copy of the prosecutor's request for discovery and witness list?
Yes, Your Honor.
All right, and how do you wish to proceed today on behalf of Mr. Opel?
Your Honor, I believe this matter is going to be resolved very quickly, Your Honor. But if we could just have the quickest pretrial we can for a plea, Your Honor.
So, Ms. Underwood, I actually misspoke. For some reason, I have the felony information out of order. So I apologize. It looks like this is actually a first pretrial. I apologize.
I thought it was.
Yeah, my documents are just out of order. I'm sorry. So first available pretrial?
Yeah, very quick, Your Honor.
About October 18th at 8:30 in the morning.
That would be great. And Mr. Opel, if we can get you in sooner for a plea, if we get this resolved quickly, I just want to discuss possible COBs with the judge and Ms. Meir.
All right, is it possible, you can give me a Zoom meeting again sometime soon?
I'm sorry?
Could you give me a Zoom meeting sometime soon?
Yes,
After?
yes. We Zoomed yesterday, but
Yes,
okay, yeah. Okay,
all right, thank you.
All right, and you'll do the stip in order to adjourn with sign Mr. Sneed's name with permission. All right, so Mr. Opel, if you could let them know, I'll take Mr. Madison or Mr. Bowerman next, please.
Yes, Judge, thank you.
All right, thank you.
No, thank you.
All right, Mr. Malaro, we are back with Ms. Smith. So in the matter of the people of the state of Michigan versus Emily Ann Smith. Mr. Malaro, how would you like to proceed today?
Your Honor, as to the two contempts, the one show cause and then the contempts from last week, we'd have to set those for a hearing. And then the underlying felony, we'd ask to adjourn that out for another pretrial.
All right, so you are asking for a hearing on the contempt of courts. So we have, do we have any witnesses, Mr. Post, other than you?
Judge, what I'll do is I'll get a hold of forensic fluids, since a swab was used. So yeah, just me and the forensic fluids.
Okay, and how should I set this out, a week, 2 weeks?
If I could maybe have 2 weeks, Judge.
Okay.
And what I'll do is I'll prepare a packet for the prosecutor.
Okay, so let me look. I actually, Mr. Malaro, we just set Zachary McFarland. You said you had a hearing in district court on October 17th at 10 a.m. Is that correct?
Yes,
Our
it is.
prelim?
Yes.
Do you expect that to go all day?
It's I think it's an attempted murder charge, so yeah, it could go a while.
Okay.
I don't think it'll go all day, Judge, but it'll go a while.
Do you think I could set this for 3 o'clock on October 17th? Or 2 o'clock or?
That's a Tuesday, right?
Yeah.
Yeah, we should be able to do a Tuesday in the afternoon.
All right, so I'll do October 17th at 2:30. October 17th at
Could do the
2:30.
pretrial at that time as well, Judge?
Yes, so we'll do the contempt of court hearing as well as the pretrial. So Mr. Sneed, I don't know who the prosecutor is on this one, but they'll need to make sure they subpoena the witnesses. So do you want that in person, Mr. Malaro, or via Zoom?
Ms. Smith, do you want to come over to the court in person or do you want to do? Well, she's got the Rona right now, Judge, so she's probably going to have to do it by Zoom unless she's.
Okay, Ms. Smith, do you want to appear via Zoom or in person?
Via Zoom, for Zoom, please.
Okay. Okay, not a problem. All right, so we will do that via Zoom. Excellent. Okay, so I think we have to do the notice for a bench trial in the contempt of court. So we'll do the notice for October 17th at 2:30. All right, Ms. Smith, you're all set. Thank you.
Thank you.
Your Honor.
You. All right, so who do I have from the jail?
John Madden.
All right, Mr. Madison, hold on 1 second. Let me grab your file.
Yes, ma'am. How are you today, Judge?
I'm good. How are you?
Look good today.
Well, you're not doing too good because the last time I saw you weren't in custody. So
You said what?
I think last time you weren't in custody, were you?
Yeah, last time I seen you, I was in custody.
Okay. All right. So this is in the matter of the people of the state of Michigan versus John Carl Lorenzo Madison, file number 23-21479FH. I have Matthew Murphy appearing on behalf of Mr. Madison and Mr. Sneed appearing on behalf of the people. I do have a memorandum in my file that was provided to me by Darren Coast, pretrial services coordinator, stating that Mr. Madison's drug testing conditions are regular and random. So Mr. Coast, I think I found him. How long have you been in jail, Mr. Madison?
Been in jail, I think it's 12 days, 10 days now.
Okay. So I do know where he is now. Mr. Coast had stated that at that point, he wasn't able to reach you and he would like to get you on a tether, or you're on tether, but he would like you tested on a regular basis. Okay, so we have a motion affidavit and bench warrant that was amended and filed with the court on September 26th with the allegations that Mr. Madison stated he would be dirty for drugs while on the record with the judge on September 26th. In the morning, he failed to return calls to be drug tested on May 5, May 12, May 26, and August 16. As of September 25 of 23, his phone number is longer in service and we were unable to reach him. Mr. Madison, weren't you screened for drug court?
No, I this is my second, I was supposed to come see you, but you wasn't here. So I seen the other guy, I don't know his name, Oslaver, whatever his name is. And this is
Olsaver,
sorry, Olsaver. And this is my second court appearance to be up here. I didn't know.
Okay.
I didn't know.
I think I was
Hold
going
on,
to ask.
So Mr. Madison, hold on 1 second. All right, Mr. Murphy.
Your Honor, I was going to see if we could have him screened for drug court, but the process hadn't initiated. And then there is that this issue of the failing to comply, I guess, to the allegation of failing to comply with drug testing conditions. So what I was going to ask for today will be an adjournment, again, for a screening for drug court to see if you qualify for that. If that would be a good option for him, given the situation, and if we could possibly address bond on his case as well.
Right, so, hold on 1 second, everybody, hold on. So my next drug court is, hold on, looking. Thursday. So my next drug court is October 12th. So if you submit the application, we would be able to screen him more likely than not on October 12th to determine if he's eligible and so forth. So
We'll put that
Mr.
screening
Madison,
today.
he's got a screening today for drug court?
No, we'll put the request in to screen him today. I'll have that put in today.
All right, so Mr. Madison, do you want to be screened to see if you're eligible for the drug court program?
Yes, ma'am. I was gonna ask, I was gonna ask that anyway. I need help. I do need help.
Yep, I got it. All right, and then what I would say, Mr. Murphy, is if we screen him on the 12th, I'd like to see him back here for pretrial on the 18th.
Yes, Your Honor.
All right, so Mr. Madison, Mr. Murphy will get the information to the screening committee to have you screened for drug court. And then I will set you for pretrial on both the contempt of court and the underlying file on October 18th at 8:30 in the morning. I will tell you, Mr. Madison, typically, if you're admitted to drug court, in light of your recent use, you would go more than likely from jail to an inpatient program.
Would you say again, ma'am? I didn't hear you.
So because of your recent use, more likely than not, if you're accepted into the drug court program, you would go to an inpatient program for about 90 to 120 days. Do you understand that?
Yes, yes.
Okay.
All
right. And go ahead, Mr. Madison.
Can I speak to Mr. Murphy?
Well, hold on. Let me finish my little thing, and then I'll give you time to talk to Mr. Murphy. So, Mr. Murphy, in light of that, I realize you want to address bond, but I do have some grave concerns about that, and we're coming back in 2 weeks.
Yes, Your Honor, I'd actually just wanted, he does have actually, I noticed a new pending felony that was charged up for probable cause down in district court. I know he's being held on that bond. So I just wanted this bond to be a possibly postable bond if he could. I don't anticipate anything being done with it until we get the new case figured out on what's the bond on that's going to be. But that's really all I wanted to make sure he had, if the court was willing to allow a postable bond, a reasonable and postable bond, if you could do that.
Yes,
I can change it.
Your Honor, I have to go because I talked to them downstairs to what's the guy's name downstairs? The judge?
Judge Morgan?
Todd Morgan. Yeah, is it Todd Morgan? Yeah, I have to go 3 times a week and drop and do randoms, and I can't be in no alcohol. He said he's fine with that, letting me get out and letting me do that. So if you could change it for me, as long as I really appreciate that.
Well, I don't know that I'm comfortable with that since you weren't doing your testing up here.
Yes, ma'am.
So here's what I'm going to do.
Yes,
I'm going to change your bond to a 5,000 cash surety bond. With the remaining conditions, if you are released on bond, I would also require tether.
Judge, he's actually already on tether.
Okay,
but I do
they
want
must
him.
have taken it off though, right?
They just took it off yesterday.
Okay. So that tether requirement would still stay. If you don't get released, we'll see you back here on the 18th, okay?
Thank you.
If you get released, if you post that bond, and it's Monday through Friday from 8 to 4:30, excluding lunch from 12 to 1, you gotta go see Mr. Coast. I know that you got conditions down in district court, but understand those are different. So you gotta see Mr. Coast and whoever you gotta see in district court. Do you understand that?
Yes, ma'am.
So you come to the 3rd floor, you check in at the clerk's office and tell me you need to speak with Mr. Coast, okay?
Yes, ma'am.
All right, otherwise I will see you back on October 18th at 8:30 in the morning. All right, thank you,
Judge.
Mr. Madison.
Thank you.
Thank you, Mr. Madison. I'll come visit you as soon as I can, okay?
All right.
Don't disconnect, and could you ask them if they could get Mr. Bowerman for me?
Yes, ma'am. He's my bunkie.
Okay.
Yes, ma'am. All right, they want borrow me.
Mr. Murphy, let's see, we have Barton. So in the matter of the people of the state of Michigan versus Blake Anthony William Barton, file number 2023-212-72FH. You represent him on the underlying file. I have a motion and order to show cause that was filed with the court on September 11th and mailed to Mr. Barton. Ordering him to appear today at 8:15 in the morning, and the allegation is he failed to do a PBT on August 21, September 4, September 6, September 9, and September 10. He also consistently fails to charge his remote breath device. So we have issued a bench warrant. He is not, we have issued the show cause. He has not appeared. Mr. Coast, have you had any further contact with him?
Judge, I have not. He knew to be here too.
Mr. Murphy?
Your Honor, I haven't spoken with Mr. Barton in a bit. We did set trial. I had anticipated speaking with him again here shortly before the trial. But this is the first time I've heard about this. I haven't received any of the information for this. So obviously, I guess nothing more I can say in regards to the matter.
All right, so I am going to issue a bench warrant for failure to appear. And his underlying charge is operating while intoxicated, third offense notice. It's yeah. So I'm going to set bond in the amount of 50,000 cash. And if you hear from him, obviously I don't sign those for 48 hours. So if you hear from him, let us know and we can arrange for him to get in to see Mr. Coast immediately. All right?
Yes, Your Honor. Thank you.
All right. Thank you. Mr. Bowerman, good morning.
Good morning, Miss Angelo. How are you, Your Honor?
I am good. How are you?
I'm hanging in there. Thank you for asking.
So this is in the matter of the people of the state of Michigan versus Gary Scott Bowerman. We have two files, 23-21342FH, 23-21445FH. I have Matthew Murphy appearing on behalf of Mr. Bowerman, and I'm sorry, I have Mr. Sneed appearing on behalf of the people. So, Mr. Murphy, this is the date and time set for a pre-trial, first pre-trial on these files. So how would you like to proceed today with Mr. Bowerman?
Your Honor, could I speak to Mr. Bowerman in a breakout session, please?
Sure. So, Mr. Bowerman, I am going to open a breakout room.
Okay.
And I'm going to put you and Mr. Murphy. And go ahead and hold on, almost there. All right, go ahead and join that breakout room.
Okay.
And Miss Adams, if you can let the jail know I'm booking on the, I can call booking.
Okay, great.
Hi, this is Judge Anslone. How are you?
Good, how you doing?
Well, we had a pickup on a Scott Rogers. Is he able to zoom in today?
He is, we've got somebody in the booth right now, but we can set them up as soon as they're done.
Okay, thank you.
You're welcome.
Have a good day.
Yeah.
Bye.
We have Mr.
Miss-
Rogers and Ms. Contreras, Your Honor.
So Ms. Contreras is set for 11. So Mr. Murphy is in a breakout room with the second floor jail room. So as soon as I'm done with that file, we'll have Ms. Contreras brought in. And then Mr. Rogers is on the first floor because he's a new arrest. And they only have one room right now down there and there's somebody in it. So they will be next.
Thank you.
All right. All right, Mr. Murphy, we are back with Mr. Bowerman. So, Mr. Murphy, how would you like to proceed with Mr. Bowerman today?
Your Honor, at this time, I'm still trying to discuss the matter with the prosecution to figure out what offer we have encompassing all of Mr. Bowerman's cases. I know Mr. Bowerman was approved for drug court. He did let me know that he just was he had a bed for him. He was supposed to go to Hope House on the 28th of September, but was denied because I think the bond on this case is holding him. So I was going to ask the court was to consider setting the case for another pretrial. I do believe we'll have a resolution worked out. It's just a matter of getting the communication properly with myself and the prosecutors. But if the court would be willing to change Mr. Barman's bond, if not to a PR bond, then to allow him to be released, well, on bond to, again, it was a Hope House that had a place for him. I assume that's going to be up for him again here soon, hopefully. But that's what I'm asking for today.
Was that through drug court?
I think it was not through drug court, Your Honor. I think it was just a 30-day save. I don't think it was through drug court.
So
again, it came up down when he was on. So.
Right, but if he's admitted to drug court, he's going to probably, we'll look at a 90 to 120 day lockdown inpatient. So I'm just going to set this over 2 weeks to the 18th, and then we can address it again then. Mr. Sneed, Mr. Bianetto is the prosecutor on this one, correct?
Yes, that's correct.
Okay, so we'll have to, all right, so Mr. Bowerman, I'm going to set this over to October 18th at 8:30. If you've been admitted to the drug court program, the screening process will involve you going to an inpatient. It's a much longer term one usually. So we can address all of that when we come back on the 18th, okay?
All right, thank you.
All right, so we'll see you back on October 18th at 8:30 in the morning. Thank you, Mr. Bowerman. Could you let them know I'd like to see Miss Contreras next?
Yes.
Thank you, Mr. Bowerman.
Thank you. Thank you, guys. Have a good day.
You too. All right, so Mr. Murphy, I do believe I only have Miss Contreras and a pickup on Scott Rogers.
Yeah, I think that was all that I had scheduled.
Yep, I think that's all you had this morning. Mr. Malaro?
I would have a good day. Thank you.
You too.
Yes,
Mr.
Judge.
Malaro?
Yes, Your Honor.
Are you hanging around for a case? Did I miss you on anything?
I have nothing on my schedule, but sometimes, you know, the court needs assistance from the public defense. Not that you need assistance, just that if a case pops
From
up,
a veteran attorney like yourself.
you know, if a case pops up, no, you're more than capable, Judge. Hey, by the way, I ran into Judge Pickard last night.
Did you? How's he doing?
He's looking good. He's probably shouldn't say this on YouTube, so, but he's looking good. He's looking good.
Yeah, he is like more healthy and active than most of us here today.
Yes, very active. And his wife was looking good as well. So they live because they live in Blissfield now.
Yeah, well, we shouldn't say that, but yeah, there he is. There's his portrait.
Yeah, I told him the portrait looked very nice, but I wondered if he shouldn't have held with the precedent sent by Judge Sheridan and had his head shaved with an earring for his portrait, but he said no, he didn't think he wanted to do that.
I can't imagine Judge Pickard would get anything pierced. So. No.
So well, I'll tell you, I ran into him. He's looking good.
When I get my portrait, I'm going to do a QR code like they do on the tombstones. Have you seen that?
No.
So if you go to cemeteries now, a lot of them will have a QR code, and then you can watch a video of the deceased.
Oh.
And so I was going to do a QR code on my nameplate to like probably my witch sentencing or something like that. So.
Oh, technology. What's your QR code going to be, Mr. Sneed?
Have to give us some thoughts. First I've heard of this.
Your numerous hole-in-ones?
That's right. He's a golfer.
Did you do Caleb Anderson or Simpson?
Caleb Simpson, yes. Let me find it. It was adjourned.
Okay.
Hold on. Let me find it. Caleb Simpson was adjourned and the date was to be determined. We didn't call it on the record. I'm sorry.
Gotcha.
And Mr. Coast sent a chat. So let me go back to that. So Mr. Coast, you stated that Mr. Barton got a hold of you?
Judge, I actually called him after he entered that bench warrant. And he indicated me, he said, Darren, you said that you're going to dismiss that contempt as long as I was fitted with a scram. He said he was fitted one with last Friday. So I did get a hold of JSG and they did confirm that he was fitted with that scram unit. So at this time, I'd actually like to dismiss that violation if possible.
Okay, so, all right, so let me find this file again. Do we have a pre-trial set? All right, so Ms. Underwood, this is your file, right? Or no, Mr. Murphy is gone. But all right, so in the matter of the people of the state of Michigan versus Blake Barton, I'm going to dismiss the bench warrant or quash the bench warrant. And I'm going to continue it to the November 8th of 23 pre-trial with a trial date of December 6th of 23. So Ms. Underwood, if you can text or Mr. Murphy and let him know that I quashed that bench warrant.
And Judge, I'll get a hold of Mr. Barton too and let him know of his next pre-trial date.
Okay, all right, and contact his attorney. Thank you, Mr. Coast.
Thank you.
All right, Mr. Rogers. Okay, get your file. All right, this is in the matter of the people of the state of Michigan versus Scott Allen Rogers. We have file number 21-20250 FH, 21-20251 FH, 21-20277 FH, 22-20984 FH, and 22-21010 FH. So, Mr. Rogers, we are here on each of these files on two things. So there was a, let me get back there, was a request and summons for probation violation that was mailed out on each of these files and signed by me on July 6th of 2023 and filed with the court on July 11th of 2023. On each of those files, it alleges that you have violated the terms of your probation by failing to report as often as required. Now, Mr. Rogers, if you were to plead guilty or be found guilty of that violation of probation, on file number 21-20250 FH, the maximum penalty could be up to 4 years in prison. On file number 21-20251 FH, the maximum sentence if you pled guilty or found guilty on that one could be up to 10 years in prison. Could be up to 10 years. And on file number 21-20277 FH, if you pled guilty or are found guilty on that one, it's a retail fraud. The maximum penalty could be up to 5 years in prison. And on file number 22-20984 FH, if you pled guilty to the violation of probation, the maximum penalty could be up to 2 years in prison. And then on file number 22-21010 FH, on that file, if you pled guilty or were found guilty of a violation of probation, you would be facing a maximum penalty of up to 2.5 years in prison. So do you understand that would be the violation of probation? Do you understand the maximum penalty on each of those?
Yes, ma'am.
Okay, so Mr. Rogers, so outside of that, we also have a contempt of court because you were ordered to appear for probation violation, arraignment, and hearing on August 9th of 23, and you failed to appear. So that would be a contempt of court. And the maximum penalty for contempt of court could be up to 93 days in jail and or a $7,500 fine. Do you understand that?
Yes, ma'am.
Now, Mr. Rogers, you do have the right to have an attorney represent you at this and all subsequent hearings. If you can't afford to hire an attorney, we can appoint you one at public expense. Would you like an attorney appointed to represent you?
No, ma'am.
Okay, so you'd like to proceed without an attorney?
Yes, ma'am.
Okay, all right. I have one here if you want to talk to her. She's very good.
No, I'd just like to proceed, ma'am.
Okay, all right. So, Miss Underwood, I have Miss Contreras. Would you like a breakout room with her while I take care of Mr. Rogers?
Yes, thank you.
All right. So, Miss Contreras, I am going to put you in a breakout room with Miss Underwood. Just give me 2 seconds. You're in a room with a computer, so you're going to have to use the mouse to join the breakout room. And you should be getting an invitation right now.
Okay.
Thank you. So. All right, so Mr. Rogers, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, and Mr. Rogers, can you hear and understand me?
Yes, ma'am.
All right. Now, did you receive a copy of the violation of probation allegations?
I never got anything, any of that, ma'am.
Okay. All right. So, Miss Adams, could you let the jail know that he needs to be provided a copy of the paperwork? Are you satisfied that I read those documents to you?
Yeah. Yes, ma'am. I'm fine with that. Yes.
Okay. So we will get you a copy of that. Now, do you understand that you have a right to contest the violation of probation charge as well as the contempt of court charge and to have a hearing on it? Do you understand that?
Yes, ma'am.
All right. Do you understand that throughout that hearing, you would be presumed innocent until your guilt is proven by a preponderance of the evidence? Do you understand that?
Yes.
You have a right to have all the witnesses against you appear at your hearing, to have your lawyer, if you had one, ask them questions, or you could ask them yourself, and to have me order any witnesses you might have to appear at the trial. Do you understand all of that?
Yes.
All right. You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand that?
Yes, ma'am.
On the other hand, do you understand that you have a right to testify at that hearing or trial if you wanted to?
Yes.
All right. So, Mr. Rogers, with regard to the violation of probation on each of these files, how do you plead to the charge that you violated the terms of your probation by failing to report to probation after being discharged from treatment on July 2nd of 2023? Guilty or not guilty?
I'm guilty, man, but they threw me out of rehab because I had COVID, which you know, I spiraled out of control. I'm guilty. I'm guilty.
Okay, so when you got kicked out of it, I understand that you were removed because you got COVID. Okay, but you should have called Sarah or reported to her, right?
Well, no. They knew. No, I talked to Amy a few times, and she said that I had to quarantine for 14 days. You know, I couldn't do anything with drug court for 14 days and all that. Well, I woke up in the hospital, and you know, so, but I'm guilty, ma'am. I'm guilty. You know, I don't.
Okay,
you know, I don't want to give you no excuses.
Well, hold on. I just want to walk through it with you, Mr. Rogers. So you were released from the program. You had COVID. At some point, you went to the hospital because of the COVID symptoms?
And yes, ma'am. I was unconscious. I woke up in the hospital, and my mom was here from Houston. So I wake up in the hospital, and my mom's here from Houston, Texas, right? I'm out of my mind. I don't even know what's going on. I don't remember. I can't even think at this point. So I wake up and I'm in Houston, Texas. I don't even know that I'm on probation. I can't, you know what I'm saying? So I'm there about a week and I'm like starting to remember things. I'm like, oh my God, I got drug court, this and that. So once I got completely clean, which I've been clean for 74 days, I came back and turned myself in. And here I am. So, but I'm guilty.
But you never reported to Miss Teskey. You just came and turned yourself in.
Yes, ma'am. Well, I thought Miss Teskey would have been here yesterday because it was Tuesday, you know, we report and she wasn't here. So I had Amy, I got in contact with Amy and her and I came to the courthouse and I turned myself in.
All right, and good. I'm glad you did that.
But I am clean, ma'am, and I believe if I didn't leave, if I didn't do what happened, I don't know what would have happened. So, but.
Okay, so where were you on August 9th?
In Houston, Texas.
Were you in the hospital?
Excuse me?
Were you in the hospital on August 9th?
I was not.
Okay.
I was not.
Okay.
I was getting my with family, getting myself together, getting my house, you know.
And how did you get to Texas?
Flew on an airplane.
Okay. And you know, okay. All right. Okay, so I just asked, so you're pleading guilty to the, I had to backtrack because I forgot. So you're gonna plead guilty to the probation violation. So you said you would plead guilty on that, yes. So how do you plead to the guilty? Okay.
Guilty.
But how do you, okay, hold on. How do you plead to the charge that you failed to appear for the probation violation hearing on August 9th of 2023?
I mean, I didn't know nothing about it, but I'm guilty. I mean,
well, you didn't know anything about it because you left the state of Michigan and weren't getting your mail, right?
Yeah, exactly.
Okay. All right. So you pleading guilty?
Yes, ma'am. Yes,
okay. All right. Has anything been, do you understand if you plead guilty, you give your right up to a trial? Do you understand that?
Yes, ma'am. Yes, ma'am.
Okay. And you sure you don't want a court-appointed attorney?
Yes, ma'am.
Okay. Has anything been promised you to get you to plead guilty?
No, ma'am.
Has anyone threatened you in any way to get you to plead guilty?
No, ma'am.
If I accept this plea, you'll be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, ma'am.
And it's your own choice to plead guilty to both of these.
Yes, ma'am.
All right. So, Mr. Rogers, we've gone through most of this, but all right. So you were released from the inpatient program you were at because you tested positive for COVID.
Yes.
Okay. And when that was July 6th, right?
Yes, somewhere in there, yes.
Or July 2nd. All right, so from July 2nd, where did you go on July 2nd when you got out of the program?
I came back to Adrian. The minute I pulled out of the rehab, I called Amy and you know, told her what was going on, asked her what I should do. She says, I can't be going to drop. I can't do anything for drug court for 14 days. So I'm back. I'm back in Adrian. And then I woke up in the hospital in Adrian on, I believe, July 21st.
Okay. Okay. So you were in the hospital. You were in the hospital in Adrian on July 21st.
With my mom here from Houston, Texas, yes.
Okay. And then at some point you got on a plane and you went to Houston.
Yes.
Okay.
Like
And I'm not going to violate you for leaving the state because you've admitted it and it'll be part of it, but it's not going to be a separate violation. All right. And then you didn't get your mail and you didn't appear for the probation violation. But would you agree that after the 14 days passed, you didn't come to court on a Tuesday to see Ms. Teskey?
Yes, ma'am.
Okay. All right, I accept the pleas. They've been given understandably, voluntarily, and accurately. You do have full knowledge of your rights. You waive counsel. I'm going to refer this matter to the probation department for a pre-sentence investigation. I'm going to set this for sentencing on October 12th at 8 a.m. Hold on. Do you want an attorney for sentencing?
Yeah, sure. I mean, I don't know what to do here, so yes.
Well, they can go through and explain stuff to you. So, all right. So, Ms. Underwood, Mr. Rogers pled guilty to the contempt of court and the MOP. And I'm going to set sentencing for October 12th at 8 a.m. So, Ms. Underwood will get a copy of your pre-sentence or your probation violation, and she'll review that with you. She's really good about meeting with people at the jail. She's able to get in. And we'll see you back here on October 12th at 8 a.m. Okay?
Thank you, ma'am.
All right. Thank you, Mr. Rogers. Okay.
Your Honor, as to Ms. Contreras.
Hold on. I got to call the case. Hold on. You just wait for me 1 minute. All right. Well, where'd she go? Let me get her back. Hold on. I'll close the breakout room and get her back. We are on the record in the matter of, do you go by Angelica or Angelica?
Angelica.
Okay. We're back on the record in the matter of the people of the state of Michigan versus Angelica Maria Contreras. And this is file number 22-21026FH. This is the date and time set for hearing. Let's see, we have a motion, affidavit, and bench warrant that was issued for failure to appear on, let's see. So we have, all right, so we have a request and summons for probation violation that was sent out, signed by me on August 1, and it looks like it was filed with the court on August 4th, alleging that Ms. Contreras has violated the terms of her probation by failing to report on or about July 31 of 2023. Her current whereabouts were unknown. This is a Ms. Walsh file, but I am filing today. And then notice of hearing was given to appear on August 17th of 2023 at 8 a.m. And she failed to appear. So a motion and affidavit and bench warrant was issued for failure to appear. And so the maximum penalty, if she were to plead guilty on the violation of probation, could be, I think we said this was a 2.5 year, let me double check. Yeah, a 2 years. So the maximum penalty could be up to 2 years in prison. And on the contempt of court, the maximum penalty could be up to 93 days in jail and or a $7,500 fine. And she had asked for court-appointed counsel. We appointed Ms. Underwood. Ms. Underwood, how do you wish to proceed today with Ms. Contreras?
Well, Your Honor, all I received was the motion and affidavit for bench warrant. I did not receive the original show cause for the violation. So.
All right, so hold on. That would have gone probably to the general PD thing, so I apologize. And we're going to send that to you right now. And I am also sending you a screenshot. So we will get that to you. So how do you want to proceed?
Thank you. If I could just have another second with Ms. Contreras.
All right. So Ms. Contreras, I'm going to pop you back into that breakout room. I'm opening it now.
I'm gonna take off if that's okay.
Well, if you have better things to do, I guess.
Well, I wouldn't categorize them as better, but
All right, thanks, Mr. Malara.
have a good day, Judge.
You too. All right, let me close that breakout room. All right, so Ms. Underwood, now have you had enough time to speak with Ms. Contreras?
Yes, Your Honor, thank you. Ms. Contreras is going to plead guilty to the violation, Your Honor.
All right, and the contempt of court?
Yes, that is right.
Right, so Ms. Contreras, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you can put your hand down. All right, thank you. So do you understand, you have two things here today, contempt of court as well as a violation of probation?
Yes, ma'am.
Okay, now you would ask for court-appointed counsel, and we appointed Ms. Underwood to represent you. Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, ma'am.
All right, and do you understand that you have a right to contest the violation of probation charge and the contempt of court?
Yes, ma'am.
Okay, and do you understand that you would have a right to have a hearing, and during that hearing, you would be presumed innocent until your guilt is proven by a preponderance of the evidence? Do you understand that?
Yes, ma'am.
Yep, now you're gonna make me yawn because you yawned.
Sorry, I'm so sorry.
It's okay. All right, you have a right to have all the witnesses against you appear at your hearing, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at the hearing. Do you understand all of that?
Yes, ma'am.
You would not have to testify at that hearing, and no one could say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, ma'am.
On the other hand, do you understand that you would have a right to testify if you wanted to testify?
Yes, ma'am.
Right, on both of these files, how do you plead to the alleged violation of probation that you violated the terms of your probation by failing to report on or about July 31 of 2023 or any time thereafter? Guilty or not guilty?
Guilty.
All right, and on the contempt of court, how do you plead to the charge that you failed to appear for arraignment pretrial on the violation of probation show cause on August 17 of 2023? Guilty or not guilty?
I'm guilty, Your Honor.
Right? Do you understand that by pleading guilty, you will be giving up the right to a hearing, as I've already explained to you?
Yes, ma'am.
Has anything been promised to you to get you to plead guilty?
No, ma'am.
Has anyone threatened you in any way to get you to plead guilty?
No, ma'am.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during the hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, ma'am.
Is it your own choice to plead guilty?
Yes, ma'am.
All right, so Ms. Contreras, you were placed on probation. One of the conditions of your probation is that you were supposed to report to the probation department. Is that correct?
Yes, ma'am.
Now, were you supposed to report to probation on or about, well, on July 31st of 2023?
Yes, ma'am.
And did you report?
No, ma'am.
Right, did you report any time after that?
No, ma'am.
Okay, now, we issue show causes, so we would have sent to you in the mail a notice to appear on August 17th of 23 at 8 AM for a show cause hearing on the violation of probation. Did you appear on August 17th of 2023 for that hearing?
No, ma'am.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. She has full knowledge of her rights. She does have competent counsel. I'm going to refer this matter to the probation department for a pre-sentence investigation. Ms. Underwood, are you available October 12th at 8 AM?
I am, Your Honor.
Right, so I'm going to set this for sentencing on October 12th at 8 AM. Ms. Contreras, Ms. Walsh will meet with you and do a probation violation report. And we'll get a copy of that to Ms. Underwood. Ms. Underwood's really good about meeting with people at the jail beforehand, but sometimes due to other things, she can't get in because they have other stuff going on. If she can't meet with you in advance, I'll give her an opportunity to meet with you that morning, all right?
Okay.
All right, and when you talk to Ms. Walsh, be truthful, and we will see you back here on that day, all right? Do you have any objection to appearing via Zoom?
No, ma'am.
Okay, so you're okay appearing via Zoom instead of in person, or?
Well,
What I'm saying is, you do have a right to be present in person for sentencing. I phrased that wrong. You have a right to be present in person for sentencing, or you can appear via Zoom. It's up to you.
Well, I'm gonna be in here, so.
Zoom?
Yeah.
Okay, so we'll do that via Zoom. All right, thank you, Ms. Contreras. We'll see you back on October 12th at 8 AM. You're all set. Ms. Underwood?
That's it, Your Honor.
Yep, that concludes our morning docket, and Ms. Womack, I'll see you back at 1:30, all right?
Okay, thank you, Judge.
Thank you. Bye.